Good evening, everyone. I'm C. Aman Rajput, and it's my privilege to welcome you all as a moderator of this important webinar organized jointly by Committee on Commercial Law, Economic Advisory, and NPO Cooperative of ICAI. It's my privilege and a pleasure to welcome you all on day one of Knowledge Express Week, organized by Committee on Commercial Law, Economic Advisory, and NPO Cooperative of ICAI. The Knowledge Express Week is held from 13th to 17th of October 2025 is a unique initiative aimed at knowledge sharing, professional development, and awareness of emerging issues in the field of law, economic advisory, and corporative matters relevant to the profession. Now, let me brief you to the work of this committee. This committee plays a vital role in enabling chartered accountants to shape strategies and policies that unlock economic, financial, and social values while combining analytical foresight with commercial acumen. Its core functions include policy analysis and knowledge sharing, offering inputs to regulators and crucial legislative and economic matters, developing technical guidance and background material, and creating awareness on professional opportunities in commercial law, economic advisory, and NPO related matters. Through this initiative, like today's session, the committee continues to build capacity and awareness in areas of professional importance. Now, I'd like to invite Abhay sir, our chairman of this committee, for his opening remarks.
Thank you very much. Thank you, Aman, the moderator of this first session of the Knowledge Express Week. And I'm very pleased and happy to welcome our own Central Council member, CA Pankaj Shah from Indore. Pankaj, thank you so much for joining. I think you are the opening batsman for this Knowledge Express Week and very important session you will be discussing today on the succession planning. I think uh, I must say the topic is now been picking up so quickly and members are really keen and interested, to listen to this very important topic on succession planning, how whether we talk about family, we talk about offices, enterprises, even at home. So I think this is one of the key areas where members, I'm sure, would like to know. Thank you, Pankaj, for your consent out of your busy schedule. You've given us time today for this very important session. And I think we'll have also be joined by us very soon, CA Sumit Nema from Indore.
He has joined. He's
Has he
already joined.
joined? Okay. Yes, Sumitji, hi. Good evening. So we have Sumit Nema, Chartered Accountant, Senior Advocate from Indore. Thank you so much, Sumitji, for sparing your valuable time. I know your schedule is so tied up, so we always get an opportunity after 5, and it's 5, so we are happy to have you here. Thank you so much for joining,
Thank
and
you.
of course, the office for initiating and starting this very important Knowledge Express Week, the Mayank who's there from the office. So just to give you this, it's an immense pleasure and privilege for me to welcome all of you at the inaugural session on the Knowledge Express Week. As already mentioned by Aman, that this week is a long week running from 13th to 17th of October under the Committee on Commercial Law, Economic Advisory, NPO, and Cooperative, is more designed to foster learning and professional advancement across spectrum of emerging and foundational topics. So including, of course, very important topic today is the succession planning. And then we have RERA, we have decided to have FEMA, dispute resolution, and other cooperative related matters which we have taken in this Knowledge Express Week. To just share as a chairman of this committee and vice chairman, of course, CA Pramod Jain. So both of us have taken a number of initiatives during the year. More importantly, our flagship studies, which we consolidated and compiled a wonderful publication, which is on RERA, study on strengthening RERA in India for future best practices recommendation. So this was released by our Honorable President, Vice President, and Council members during the August Council meeting, and then formally was unveiled during the NARADCO National Convention at Delhi. So this is a publication on RERA which covers study on the entire or the respective states' RERA authorities, what are the best practices, the recommendations, and the opportunities for chartered accountants. So I would request members, participants who have joined today, who have always been an encouragement for any such webinar which we initiate from this committee. I think you are the pillars for us. You are the encouraging participants which help us to organize such webinars. And that is what has made us to continue our Know Your Law series, which we have achieved in 116 webinars, which have almost covered 10,000 plus participants in the last 2 years. So this is each day the strength, the numbers are growing, the participants are growing. And I must say, if you talk about income tax, GST, company law, this is one area where we have committees. But any other commercial law or allied laws you talk is this commercial law committee. So we have so much in this committee that has made us to initiate certificate courses. And I'll tell you, if you go to the webpage of committee, there are 11 such certificate courses on different commercial laws topics consisting of NPO, cooperatives, RERAs, and various other certificate courses. Initially, we started we have launched succession planning. Very soon, we'll have a batch in the month of November, December. We have already announced the course for labor laws, which is registration is going on. We've almost touched 100. So the response is tremendous. So I would sincerely request the participants to keep visiting the webpage of the committee, and your suggestions, inputs will always be useful. Leadership development program we regularly organize. We have already planned one from 7th, 8th, 9th November. That is on the RERA and the ADR, which we have planned. Then submission to Central Registrar, New Delhi, on the multi-state cooperative auditors report order. This is also MS Caro, which we have submitted our recommendation, and publications which we have been releasing. More importantly, on the professional opportunities on RERA, FEMA, ODR, and other drafting certain links or the templates which we have created this year on the web page, which you can download. So 31 such templates we have created on different partnership formats, trust deed, gives deeds, wills. These are all available on the web page at the ICI website under the committee. So please download. These are standard templates which we have created, which is vetted by experts, someone like Sumit ji, Pankaj ji, who vetted this and confirmed that these can be some good material and templates which can be used, especially by small and medium practitioners in day-to-day working, and improve the quality of documentation. So number of initiatives, some of them I've already shared, and some of them we already planned on cooperatives and other sectors. So it's demonstrate the committee's ongoing commitment to strengthening the CA profession, contributing to policy formation, various representations which we have been given time and again. So once again, I extend a heartiest welcome and heartfelt welcome to everyone joining us for this very important Knowledge Express Week, the first day of this Knowledge Express Week. And I'm sure we'll have excellent learning. We'll have a lot of questions being raised, interaction. I'm sure the participants would really be benefited. And I sincerely thank my council colleague, CA Pankaj Shah from Indore, for taking this time, taking out of his busy schedule, speaking on very important topic today, and CA Sumit Nemaji for joining us today as for his special address. So thank you so much, Aman, for this opportunity and for me to give the opening remarks as the chairman of this committee. Over to you.
Thank you, sir. Now I request Mr. Sumit Namas, sir, who is a senior advocate for keynote address on legal aspects of succession planning. Welcome, you, sir.
Before Sumit sir starts, let me just introduce about something about Sumit Nemaji. He is the youngest chartered accountant, senior advocate of India, I would say. He was designated as senior advocate at the age of 41 years, I believe, and great accolades and feats, because as a chartered accountant, he understands accountancy, and as a senior advocate, he represents cases in Supreme Court. So I would say he's my law guru. Whatever law I am learning and I have learned, it is from Sumit Nemaji. So welcome, Sumit, sir, for gracing this program. I would also like to inform you that these programs have more than 1,000 attendees in this. This is our panel link and audience. If we see, there are more than 1,000 members who are listening to this, and this will be recorded and saved for future, so that people may take advantage of your words of wisdom. So welcome, sir. We are eager to listen to you.
Thank you, Pankaj. Thank you for your kind words. And before I start, he's calling me a law guru. I call him a tech guru, because whatever hindrances are there in the audit reports of various judges, I won't name the judges. I refer those matters to Pankaj just to sort them out so that the CPC doesn't create any artificial demand. And Pankaj has been very, very kind over the years to sort out various issues regarding to various very high posted judges who have had a problem with their audit reports and the filing of the returns. So he is my tech guru. He takes care of all those small nitty gritties, including my own audit reports, which get lost in the CPC translation. So thank you, Pankaj. And Abhayji has been very kind, and he's been a great inspiration, and he's always taken time out from his various endeavors. And way back, Abhayji's father was very kind in giving me a very big case very early in my career. I had just started, and Abhayji's father trusted me with a very high profile case. And it's been a very long association. So thank you, Abhayji, for this kind invitation.
Always a pleasure.
Yeah, wonderful. Pankaj, I have had the privilege of looking into your past videos of succession. So you need to excuse me for this cheat code because that was the easiest way of preparing for this keynote. So most of it is borrowed information. That is the disclaimer at the threshold. None of it is mine. It's all from Pankaj's presentation. 4 years, 5 years, 7 years. He's been dilating on this issue. So I've borrowed a lot of things from his earlier addresses, and YouTube has been very kind in preserving those addresses. so, so this is a cheat code at the disclaimer. Now, succession planning, I would call it as a love letter to the future. It's something which you give in inheritance to the people who you love and who would be very distressed at the time when you pass away. But then this is the only way you can give them a deep love letter so as to plan out their future in advance, so that by the time your 13th day is over, they are not fighting over and cribbing over what's mine and what's yours. And there are various high profile cases. The recent one we've all seen. Karishma Kapoor's sons are fighting in the will of the father, which allegedly is a forged will. So Pankaj has been deliberating a lot on the aspects of will. And he always emphasizes that will is not a foolproof instrument. So you need to guard yourself even if you issued a will as to what are the legal challenges in case a will is contested. And borrowing from there, as per his own presentation, you need to specify the executor very well so that a will is then executed properly by that executor. And essentially, two witnesses which are to be named and who see you signing in front of them on the will. Those are the two key elements, and also the element of date. These are the three things I've borrowed from his earlier lectures, that these are the three essentials. And then, although registration is not a necessity, but it gives a time stamp on the will, and also the issue of identity of the person who has signed. Because the first allegation that comes is that it's a forged instrument. So, forgery now can be prevented essentially by getting it registered, because it gives a time value. And now almost every registrar has a video camera whereby your picture is taken at the time of execution. So both these elements of time value, that is the timing of the will, and also the identity of the person who's executed, are preserved by way of that particular registration. Although it's not essential, but it gives a great value, legal value, to the evidentiariness of the will, because the first challenge is the will is forged, that the signature is forged. B is that it has been signed under coercion. And C would be the person is of unsound mind. So almost all these three ingredients can be combated in case the will is registered. And there's a recent 2025 judgment of the Supreme Court which shifts the onus on the person who's challenging the will if a will is registered. So then the onus is on that person. This is Matpalli Lasumbai versus Matpalli Muttiya. This is a 2025 judgment, which gives the essentials of a registered will and as to when it is admissible, where it is not admissible. It's a 2025. Now, that is part A. Part B would be when you want to see everything disposed of in front of your own eyes. Will is something you write for the future. But what if you want to give it in front of you? Then the two aspects would be a gift deed and a private trust. But therein, there are two catch points. One is A, the gift deed, if you give it of an immovable property, then at least in the state of Madhya Pradesh and elsewhere also, there is a registration based on the market value of the property. So gift deed fetches a stamp duty of 7.5%, and on top of it, there is a 3% cess and other stamping charges. If it is of an immovable property, we are not talking about the taxation aspect of it, but the upfront cost of registration of a gift deed is exorbitantly high. So that is one aspect you have to look into. And the second is a private trust, which is also called a family trust. But therein again, if you are transferring an immovable property, although there is no capital gains, etc., but there again, the registration cost is exorbitantly high. It is equivalent again to the market value of the property. So these are the two aspects which prevent a person from creating, insofar as immovable properties are concerned, a gift deed or a trust deed. Movable properties, there's no problem because then the aspect of registration and the stamp value would not be there. Registration per se is required insofar as a family trust is concerned, but not the valuation thereof. Then, insofar as the various laws which govern all these aspects, we have to look into the Transfer of Property Act, the Hindu Succession Act, the Indian Succession Act, the Registration Act 1908, the Indian Trust Act 1882, the Income Tax Act, and Companies Act in case the transfer is of shares or the equivalent value of rights therein. So this is the legal aspect. The unclaimed, recently there is a portal which has been created by the ministry, which gives access to the unclaimed wealth in the form of bank accounts and also unclaimed shares. It's on a beta version right now. And the Economic Times reports that the value of assets therein are aggregating to almost $42 billion, which is 3.5 lakh crores. So this much amount is locked just because a person was not brave enough to contemplate his own death. So now I think every year, like we have a last date of filing of an audit report, we should also have a last date of creating a will, because that would help a lot of our clients. As chartered accountants, we have access to almost every balance sheet of our client. So then we can be instruments in making them create a will or a trust or a gift deed, depending on the facts and circumstances. So I would call us an acronym COW, which is the custodian of wealth, and also an acronym which is GOD, which is the guidance after or upon death. So these are the two aspects which, as chartered accountants, as legal advisors, we need to look into and plan accordingly. And I know Pankaj's preparation will cover all of these aspects. So these are the pointers which I am giving, and the rest is up to Pankaj to proceed. Thank you. Thank you very much.
Thank you, sir.
Yeah.
Now I request Pankaj sir for taking our technical session, 360-degree of succession planning. Now, first I want to introduce him. Sir is a chartered accountant, our council member, with nearly 20 years of expertise in direct taxation, business restructuring, estate planning, and valuation. He is a fellow member of ICAI He is a company secretary. He has also done his LLB honors. He is insolvency professional and a register valuer. He combines legal, financial, and strategic insights to deliver holistic solutions. serving as a central council member of ICI and having top family enterprises. He has extensive expertise with premier Mumbai firms and is recognized as thought leader, having delivered 1000 plus seminars and authored articles in leading journals, guiding clients across industries with practical and forward looking advisory. Even personally speaking, I have moderated three webinars and seminars of Pankaj sir personally. So we welcome you, sir.
Thank you, Aman. Thank you very much. At the outset, I am thankful to the chairman of the very vibrant committee of ICI now on commercial laws, C. Abhay Chajed ji. Thank you, Abhay bhai, for giving me this opportunity on this very, very important topic, which is actually budding out to be a new opportunity for young professionals, for young chartered accountants. And it is my great privilege to speak before none other, the legal doyen of the profession, Sumit Nimaji. Sumit sir, you may have watched my earlier presentation, but every time I make efforts to do something new. So maybe this time in this presentation, you may find something which you have not seen in the videos. At the outset, I'm very thankful to the committee, Pramod Jain sir, also the vice chairman of the committee, and Aman, who is very kind in his words. So, what is estate and succession planning? We are going to discuss about this. My presentation, I believe, would be visible to you all. Estate and succession planning is something very important. How did I get this idea to prepare on this topic? Uh, Once there was a gentleman who came to me to get his will vetted. When I saw that will, I asked him how much did he pay for preparation of that will. He said 5 lakh rupees. I was amazed. 5 lakh rupees for preparation of this will. What I did, I vetted it and charged 51,000 to him. So that gave me an idea that how important this field is, and maximum litigation disputes, everything is because of poor succession planning. Uh, we all know which was the mightiest empire in India or the world. In the world, it is said that Mahabharat, Hastinapur, was the mightiest empire which had Kaurav, Pandav, Bhishma, Pitama, everybody. But it could not succeed. Hastinapur fell down because there was poor succession planning. We know we have lessons from the past. We have seen Bhushan Group 10-year dispute and it wiped 1 billion USD as its value because there was no proper succession planning. Whereas on other example, we have seen Reliance when there was separation between the brothers and timely intervention and succession planning through intervention of mother survived the group and grew it. Dabur, on the other hand, had its succession planning properly, so it has grown like anything. Friends, apart from this, Sumitji gave some statistics. I would like to take it further. 76% of civil disputes are actually family and property disputes. Mediation is a very important thing. And under Abhayji, we have formed recently ICI Mediation Center. This is a Section 8 company. And we have N. Venkatramanji, who's the Solicitor General of India, is the chairman of it. So it is a very important and growing field. 46,000 mediation cases. Out of 46,000, 41,503 are family disputes. Earlier, I had the figure of 2 lakh crores stuck up in unclaimed in banks, LICs, PF, etc., which has now increased to more than 3 lakh crore as per the recent Economic Times report discussed by Sumitji. So, and this is only movable property. We don't know, we cannot imagine what level of immovable property is stuck, how our country's wealth is not productively utilized because of poor succession planning. So, with this background, the importance of succession planning, I'll take a twist and new turn. In this presentation, first time I'm going to discuss in life and afterlife, both succession planning. See, as an opportunity, there is a new concept evolving about family offices, family business, family offices, and this is in life succession planning, which we'll be discussing. And what is afterlife, beyond life succession planning? Sumitji has given just a brief idea about will, interstate succession. That all we are going to discuss. But we'll start today with in life succession planning and family businesses. See, chartered accountant is a person who is the closest to any entrepreneur, any businessman, because chartered accountant knows the business. He's advising his client for his tax returns, audits, everything. And in India, if we see, majority of investments are through these family businesses. What are family businesses? If we see today's times, we have Tata Group, Birla, Ambani, Adani, Mafatlal, Wipro, Bajaj, Godrej. These are all successful groups which we are aware of. But if you go and see the background, there is a thing called Jagat Seth. Abhay bhai, you are also a Jain. You know, Manik Chand Jain was the founder of this Jagat Seth family. And interestingly, these Jagat Seths were so powerful that they were the Seths of the world. Jagat Seth is a title given because they were considered as the Seth of the world. And in the earlier 18th century, they were funding Mughal emperors. They were at the peak of their power. For 200 years, these Jagat Seths were ruling the world. They were trading across the countries. And this is important how they rose, how they went, how they uh, got channelized through proper succession planning. We were talking about Jagat Seths of India, but do you know that Mark family, it is a 350 years old family business. Yes, not 10, 20, 30, 50, 350 years old family business, which is still continuing. Mark family, it was founded by Frederick Jacob Mark in 1621 to 1678. He was the founder who was there. And right now, it is his 12th, 13th generation. There are more than, I would say, 100, 200 descendants who are in that family business. So that Merck, we have heard it is a pharmaceutical company. That business is still continuing. That is a family business. So this is the importance of family business and how family businesses are running. Vijaypat Singhania, we all know it is a very interesting and most studied out case how in life succession planning is important. He said his biggest mistake was give everything to his son, and that was decision by spur of a moment. In a moment, he felt that his son is annoyed from him, so he gave everything to his son. And later, many court cases, everything. So he has written a book. He was the chairman of Raymond Limited, which has a line that Raymond the complete man, and he is writing Vijaypat Singhania an incomplete life, his autobiography. So these autobiographies and these instances, examples tell us how important in life succession planning is also there. See, if you see a family business, it consists of three models. Business, it is a three circle model. One is a business, family, and ownership. Now, when these three coincide, so family members are running the business and owning the business. It may so happen that family members are shareholders, but there is a professional management. It may so happen that family is in charge, but owners are somebody different. So when it is a three circle model, family, business, and ownership, it is important to have a proper family business management. And what is our role? See, as a chartered accountant, we are daily consulting and advising our clients on this every aspect of their life. First aspect, I'll share some of my details. When I joined my chartered accountancy, my father knew that he's going to join me, but he said, "You will not do articleship under me." He sent me to Bombay. You go Bombay, you learn under somebody else, then come and then join. So, in life succession planning, if I directly join, I'll be the boss in my father's firm. So I may not be able to learn. People will not say me. वो कहते हैं ना सुनना भी आना चाहिए. ऐसा कई बार होता है कि हम लोग जो है बॉस बन के रहते हैं तो हमको कोई बोलता है वो डाइजेस्ट नहीं हो पाता. So therefore there has to be a proper nurturing in a family office. There should be a succession plan that when I am there, how my son or my legal heirs would join during my life only. They will join the business. They'll move ahead because this family business is important, and this stage consists of various aspects with framing a family charter. Yes, this family charter is also very important. You won't believe family offices, good law firms are charging more than 10 lakh just to draft a family charter. And what is a family charter? Everybody in the family may come together, and the original values which the family has, it may be related to religion, it may be related to spending everything. So the cultural thing may be drafted and put in a charter. For example, if there is a family business, so no son's marriage will have more than this much spending, or the family money will be used only to buy a car to the extent of, say, Innova or something. So that if somebody spends more, somebody spends less, there are feuds. To avoid those feuds, these kind of family charters are created. Then counseling, every time when there is a dispute, वो कहते हैं ना बात करो तो बात बनेगी. It is very important to have a conversation, and for creating conversation where two brothers are not on talking terms, there is the need involvement of a chartered accountant who can be a good counselor. So he can make them sit together. There are cleansing sessions. You won't believe cleansing sessions where people come, we make them sit together and shout on each other. You shout, you speak whatever you want, you curse each other. After that, when everything comes out, then they will sit together and come to a resolution. So these kind of cleansing sessions are also important because there are misconceptions, misunderstandings. So this is also a very important service which our members can give, chartered accountants can give under family business management. Asset management. See, asset management also we can give advices to our clients. In today's time, asset management itself is a very important field. So we can give basic advice and take services of some experts, some registered, semi-registered investment advisors. But this is a professional opportunity in this family office concern. First and very important, nurturing the next generation to succeed. It is seen, it is said that वकील का बेटा वकील बनेगा, डॉक्टर का बेटा डॉक्टर बनेगा, सीए का बेटा सीए बनेगा. That was old saying. But nowadays we see that our children or the new generation, especially this Gen Z, which is being called, is not joining the parents' business or the family business. So how you can do planning from the childhood so that the child comes and sits and learns things. So how to nurture the second generation is very important. So in the early years also, like I'll tell my example, when I was a small kid, say I was in 8th, 10th class, my father used to take me to his office during my summer vacations. So I used to just see, do some typing of returns, learn, observe. And since I was observing it, all those things go into my subconscious mind. And ultimately make my vision that yes, this is a good field. I see how people respected my father. So that is also very important that when you see the respect which this profession commands, you'll automatically be inclined. So that is the first stage. Then nurturing, doing articleship in Bombay under the same field, and then coming back and joining the business, then leading, expanding. So it is basically a transition stage on which we can advise. We can make a whole nurturing plan, transition plan for our HNI clients. Moving ahead, family constitution. As I said, family constitution is something which is already in practice. We just need to document it and living it. See, developing of family constitution, we charge fees up to 10 lakh rupees for developing one constitution. And it is basically sitting together, discussing, interacting with the family patriarch who founded the business to the younger generation, understanding their needs, requirements, expectations from each other, bringing them together and documenting it. And it is not the only one-time process that we have made this family charter. We have to ensure that the family lives by the charter also. Yes, there may be breakdowns, breakthroughs, but again, we have to ensure by communication, by ensuring talks, we bring everything together. It is a lifelong process and not a one day thing or one time assignment. So, family constitution drafting and ensuring is also a very important part which our professionals can do. For developing a family constitution, first we need to make the families understand that what is the need and requirement. So setting up of a steering committee and planning the first session with the family, we need to create awareness कि बॉस आप ये फैमिली कॉन्स्टिट्यूशन बनाएं, इससे आपकी फैमिली को लॉन्ग टर्म में अच्छा रहेगा. इंट्रोडक्टरी वर्कशॉप, then we have to explain everybody how will it will be, then one-to-one session with family members, because it is very important to understand the expectation. And the most important part in on this is you don't need to speak, you need to listen, and you need to extract what is in the mind of other persons. Debrief presentation on family strength. After understanding everything, you need to find out what is the biggest strength of the family and how it can increase. Then, as I said, there will be some cleansing sessions where people may fight, speak something ill to each other, but then it will be a cleansing session. It is said that a volcano, if it does not burst, it creates more problem. But when the volcano bursts, everything comes out, then there is a peace. So it is very important to have these cleansing sessions also in the family. Then finalize the outcome. What do you expect from the family constitution? Then you meet everybody, and in the process you evolve, you create a documentation which will be there lifelong. It will be a dynamic family constitution. Whenever it is felt, it can be amended, it can be changed, it can be developed. So it is like you have to hold the handhold your younger generation and bring him to where you are, and you can decide your own objectives. So it is like You have to nurture and bring your younger generation to the family business. Family business is a very strong thing, very important thing. Your family business is very good, but if your children are going abroad and settling abroad, there is no benefit. They may earn millions, but importance is that this family business, family name, goodwill which you have created for so many years should be preserved. Then moving ahead, this was about in-life succession planning. I would also request if anybody has any doubts, those doubts can also be considered. You can write in the chat box because these are something new and interesting opportunities which are developing in this. Talking about afterlife succession planning, what happens when a person goes? See, afterlife succession planning, one very important thing is nomination. Yes, nomination is very important because if there is no nomination, there will be a dispute who will get the property, how will you will get the property. Nomination is basically a stopgap arrangement. A family may have nominated somebody and the property is intended to be given to somebody else. Nomination is something very important. Firstly, there is a confusion. What will prevail? Will nomination on when there is no will, there is an intestate succession. So in that case, whether nomination will prevail or not. Let me clarify it very clearly. Nomination is just a stopgap arrangement. My nominee is not owner, he is a trustee. The property will go to the person whose name is written in the will or through intestate succession rules. Succession rules will always prevail over the nomination. Nomination is just a stopgap arrangement. I'll give a best example how we can do a good succession planning. मैं अगर मेरी वाइफ को मेरी सारी प्रॉपर्टी देना चाहता हूं तो मैं अपनी वाइफ को नॉमिनी भी बना दूंगा और विल में भी उसका नाम लिख दूंगा. ऐसा नहीं हो कि मैं जो है अगर मेरे ब्रदर को प्रॉपर्टी दे रहा हूं और वाइफ को नॉमिनी बना दिया तो वो प्रॉपर्टी वाइफ के पास जाएगी, फिर वाइफ से ब्रदर को लेना जो है डिफिकल्ट रहेगा. तो आप जिसको प्रॉपर्टी देना चाहते हो, यू वांट टू गिव प्रॉपर्टी टू हूसोएवर, यू मेक हिम द नॉमिनी सो दैट देयर इज अ स्मूथ सक्सेशन. Because banks, financial institutions, securities, SEBI, everybody will give the asset initially to the nominee. And later on, when you want to recover it, the original owner to whom it was intended, he has to file a suit and take it from the nominee. So it is always advisable that whomsoever you want to give the property, you make him the nominee also. So nominee and owner, if it is the same, that is the best way of a smooth succession planning. Then, coming to succession laws, see, India has a variety of laws and it is not a single law, it is a code by itself. Why a code? Because there are different religions and different personal laws applicable. For Hindus, Hindu Succession Act; for Muslims, Muslim personal law, Sharia law is there. Then in India, the succession law is jurisprudence made law. It is not, everything is not written in the law or everything is not in the act. It may so happen that something is written in the act, but that is overridden. I'll give a simple example. If there is a company, company law says that nominee will become a owner irrespective of whatever is written in the will. But then Supreme Court, and there are various decisions, Jain, Salgaonkar and others, where Supreme Court has held that, see, company law has the objective to regulate the companies and not to decide succession. So whatever may be written, nominee will not become a owner, even though it is written in the company law that nominee will become owner. Because what will prevail, see, succession law is a specific law for that, and specific law will prevail over the general provision of a company law. So we need to remember that succession laws are not only what is written in the act or statute, but also what is jurisprudence law, which we will be discussing in subsequent slides. Coming to most important aspect, what is interstate succession? When a person goes from this world without making a will, अगर कोई व्यक्ति बिना विल बनाए इस दुनिया से चले जाता है तो क्या होगा? Now, interestingly, the rule laws are different for every person. Let me take an example. If a person dies without a will, if he is a Hindu, then Hindu succession law will apply. If he is a Muslim, then Muslim personal law Shariat Act will apply. If he is a Christian Parsi Jew, then Indian Succession Act will apply. But if there is a will, then for all except Muslims, there is an Indian Succession Act which will apply. For Muslims, Muslim personal law Shariat will prevail. Baki for Hindu, Christian, Parsi, Jew, Sikh, Jain, everybody, Indian Succession Act will apply. So from the slide, you can see that if there is no will, then your personal law will apply. If there is the will, then Indian Succession Act will apply, except in the case of Muslims. Now, coming to Hindu Succession Act, if a Hindu male dies, there is a different rule. If a Hindu female goes without a will, there is a different law. If a Hindu male dies without making a will, his whole property will be given to class 1 legal heirs. If there is no class 1 legal heir, it is a waterfall matrix. It will go to class 2 legal heir. No class 2 legal heir, then father's relative agnates. If nobody is from father, mother's relative cognates. And it is said, जिसका कोई नहीं होता, उसकी भारत सरकार होती है. So if there is no relative, nobody to claim your property, the property will go to Government of India as per Article 296, Escheat of the Indian Constitution. Who are class 1 legal heirs? To put it simply, wife, children, and mother. Yes, see the interesting aspect. My father is not my class 1 legal heir. My mother is a class 1 legal heir. My wife and my children, they are my class 1 legal heir. If a person dies without making a will and he has his mother, wife, children, 2 children, then there will be 4 equal partition of his property. One part will go to mother, one part will to wife, one part to son, and one part to daughter. So this is the class 1 legal heir status. Now, it is not so simple. Class 1 legal heir, this is a simple example, but you won't believe there are 16 different relations defined under class 1 legal heir. It is a waterfall matrix. If a person at that level is alive, then it will stop. If the person has deceased before our intestate death, then in that case, it will go downstairs. See, for this example, this old man, his mother is alive. So one portion of his property will go to mother, one to wife, one to son, and one to daughter. If his son dies before this gentleman, then to his daughter-in-law, to his grandson and granddaughter. Now, unfortunately, if son is also not there, grandson is also not there, then it will go to granddaughter-in-law, great-grandson, great-granddaughter. I'll put this aspect in Hindi, it is very important. अगर बेटा नहीं है तो पोते को पोती को, बेटा भी नहीं है पोता भी नहीं है तो पड़पोते पड़पोती को, पर बेटा नहीं है और पोती नहीं है तो पोती के बेटे को कुछ नहीं मिलेगा, पोती की बेटी को मिलेगा. अब दूसरी तरफ आ जाए, वहां जहां पर भी जो है बेटी नहीं है तो बेटी की प्रॉपर्टी जाएगी नवासे नवासी को, नवासा नहीं है तो नवासे के बेटे को कुछ नहीं मिलेगा, नवासी के बेटी को मिलेगा. पर नवासी नहीं है, बेटी भी नहीं है तो नवासी के बेटे को भी मिलेगा, बेटी को भी मिलेगा. This is the interesting part of our succession planning. These are 16 relatives defined under the Indian Succession, Hindu Succession Act, who are your class 1 legal heir. Now, if these class 1 legal heirs are not there, then the property will go to class 2 legal heir. Now, father's name comes. So if a person has not married, nobody will be there and mother has expired, so the property will go to father. If father is not there, then to siblings. If siblings are also not there, then to grandparents. And if they are not there, then parent siblings. All these are class 2 legal heirs. Then we have agnate father's relative, cognate mother's relative, and Government of India. This was Hindu male. Now talking about a non-Hindu male, what are the rules? So Indian Succession Act applies. In Indian Succession Act, your mother has no share. If your spouse and children are there, 1/3 property will go to spouse, 2/3 will be equally distributed among children. But if there are no children, then spouse will get half share and parents will get half share. So this is important. And then if only spouse is there, entire state will go to spouse. If children are there, entire state will go to children. Interestingly, in the Indian Succession Act, there is the same rule for man and woman. For Hindu male, we have understood that it is class 1, class 2, agnate, cognate. In Indian Succession Act, for a non-Hindu male, the rule is 1/3 to wife and 2/3 to children. Hindu law gives 1 share to mother. Indian Succession Act does not give any share to mother when spouse and children are there. So this is basic Indian Succession Act. Now taking some case studies. In this case study, a Hindu male is dying interstate. He leaves his mother, father, wife, son, daughter, and daughter-in-law. Who will get the estate? Mother will get, we know. Father will not get. Wife will get. Son will get. Daughter will get. Daughter-in-law will not get because son is alive. Then, coming to the next slide, in the interstate, Now you can see here that in the interstate, in this example, an interstate male is dying. He leaves behind him his wife, brother, sister, his daughter-in-law, who's also a widow, and his daughter's son. Daughter is demised. Who will get the property? See, wife will get, we all know. Brother and sister will not get because they are class 2 legal heirs. Daughter-in-law, who is a widow, will get because he will get the son's share. And daughter is not there, daughter's son is there. So daughter's share will pass on to his son. So wife, daughter-in-law, and the children of my daughter. So this is second example case study. Now in this case, the person who died was unmarried. So he has two brothers, two sisters, and one maternal grandfather. Who will get the property? See, grandparents will come later. First it is siblings. Father, then siblings. So siblings are there, so everything will go to siblings. Then moving ahead, in this case, in Hindi we say mama ka beta or chacha ki beti. If these two relatives are there, who will get? So यहाँ पर क्लास 1 क्लास 2 नहीं है, तो किसको जाएगा? एग्नेट. एग्नेट मतलब पिताजी के रिश्तेदार पहले आएंगे, फिर मदर के आएंगे. So चाचा की बेटी will get everything, not मामा का बेटा, because मामा का बेटा is cognatus. चाचा की बेटी was not there, then it would have gone to मामा का बेटा. So पहले क्लास 1, फिर क्लास 2, फिर पिताजी के रिश्तेदार, फिर मदर के रिश्तेदार, और कोई नहीं है तो फिर भारत सरकार. अब ये कैसे बटेगा ये देखें. देयर आर टू थिंग्स, पर स्टिर्पे एंड पर कैपिटा. तो पर स्टिर्पे मतलब ब्रांच लिनिएज, जो नॉर्मली फॉलो होता है कि जो जिस स्टेज पे होगा उस स्टेज के अंदर, जैसे मेरे बेटे का एक हिस्सा है और उसके 2 बेटे हैं, तो बेटे का हिस्सा ही उसके दोनों बच्चों को मिलेगा. मेरी जायदाद के जो अगर 4 हिस्से हुए हैं तो उनको 1/8 मिलेगा. तो इट इज ब्रांच वाइज. देन कुछ इंटरेस्टिंग इंपॉर्टेंट केसेस. इज योर स्टेप सन अ सन? क्या सौतेला बेटा बेटा होता है? नहीं. सी व्हाट हैपेंस, हम लोग इनकम टैक्स पढ़ के इतना इनकम टैक्स में एंग्रॉस हो गए. इनकम टैक्स से चाइल्ड इंक्लूड्स द स्टेप चाइल्ड, तो हमने मान लिया कि प्रॉपर्टी में भी ये होगा. ओनली अ नेचुरली बॉर्न चाइल्ड और एन अडॉप्टेड चाइल्ड इज अ चाइल्ड. अ स्टेप सन इज नॉट अ सन फॉर द प्रॉपर्टी अनलेस यू अडॉप्ट हिम. तो स्टेप सन इज नॉट कंसिडर्ड स्टेप चाइल्ड. सौतेले बेटे को प्रॉपर्टी नहीं मिलती है. ये इंपॉर्टेंट है. अगर आप देना चाहते हैं तो उसको अडॉप्ट करना पड़ेगा, अदरवाइज सौतेले बेटे को कुछ नहीं मिलेगा. Then adopted children. Now adoption is very interesting aspect. See, in Hindu Succession Act, a adopted child is a very well entitled to the property. But if you see Islamic law, Shariat law, there is no recognition of adoption. There they say an adopted child is the kafala. So that kafala has the lower succession right. They don't give right. Similarly, Christians and Parsis do not have a concept of adoption. However, now, as per general law, if a Christian adopts a child as per Indian law, then he will get the share in the property. So, Islamic law does not recognize adoption. For Christians and Parsis, the law is developing. But for Hindus, adoption is very well valid. If a child is adopted, he becomes entitled to equal share of the property as per class 1 legal heir. What happens with illegitimate children? See, it is said that illegitimate is not the child, but the relationship between their parents. So there is nothing like illegitimate child. And it is very interesting to see that our Hindu Succession Act gives succession rights to an illegitimate child, but Indian Succession Act does not give. You see the definition under 3(9) of Indian Succession Act. Child does not include an illegitimate child, but Hindu Adoption Act and Hindu Succession Act includes illegitimate children also. And they get the property of their mother very clearly. Now, this is something which is wrong happening with a child who has no fault because of his parents. So there are jurisprudence. Supreme Court in various cases has held that if there is an illegitimate child, he will still have succession rights, irrespective of whatever is written in Indian Succession Act, because it is not the child's fault. So he should not suffer. For mother's share, the child will get everything. There is no doubt. For father's shares also, there are some positive decisions. However, it is always advisable to have clarity in the relationship, not to engage in this kind of any disputes. Live-in relationship, this is also a concept which is very much prevalent and has been recognized by courts. Live-in partner will also get a right as a wife. As per decision of Radhika versus State of Madhya Pradesh, Supreme Court has held that a long-term live-in partner will be equivalent to wife and she'll get the property rights here. Then inter-religion marriage. What will happen? See, I'll give you an example. If there is Mr. Ramesh, who is a Hindu, he is married with Jessica, who is a Christian. and Ramesh dies without making a will. So whether Ramesh's mother will get the property or not, you will say yes, because she is class one legal here. Ramesh is a Hindu, he has not made a will, so Hindu Succession Act will apply. But there is a twist. If Ramesh marries to Jessica under inter-religion marriage, under Special Marriage Act, then on Ramesh and Ramesh's children, everybody, Indian Succession Act will apply, Hindu Succession Act will not apply. So if Ramesh marries to Jessica, because of that marriage, Ramesh's mother will lose right in his property, because Hindu Succession Act will no longer apply. It will be the Indian Succession Act will be applied. What I want to explain from these examples, that because of these uncertainties in the law and this kind of different interpretations and aspects, we should always make a will. We should ensure that there is a will to avoid this kind of different provisions of law and different variety, which is not possible for a layman to understand in the law. Now, coming to section 33 and 34 of Indian Succession Act, wife and children, they will get the property. We have already discussed about it. 1/3 goes to wife and 2/3 goes to children, which will be divided equally. This example is already given. What is under Islam? See, as a chartered accountant, we are advising to every person following every religion. In Islam, the rule says only 1/3 can be given through a will. For remaining, you cannot make a will, it will pass on through Shariat law. And there is a difference in Shariat law also. If a person is Shia, different law is applicable. If the person is Sunni, different law is applicable. Very interesting aspect, you won't believe that before 1937, there was a Khoja Muslim category where some whose forefathers were Hindus and they were converted into Muslim, they were called Khoja Muslim. And though on those Khoja Muslims, Hindu succession rules applied, though they were following Islam. I'll give you an example of some Khoja Muslims. Aga Khan, Zulfikar Ali Bhutto, Muhammad Ali Jinnah, all these were Khoja Muslims. Later on, after Muslim Personal Law Shariat Application Act 1937, Khoja Muslims are merged into Shia Muslims. So now the law applicable to Shia Muslim will apply. So there are different rules for Sunnis and Shias in Muslim Personal Law Succession Act. Now coming to female intestate. This is something very important for every female to understand, that what will happen about his property. See, for female, her mother, father will not get anything. In a Hindu male, his mother, wife and children will get everything. But for a female, her mother will not get, whether she's a Hindu female, where will the property go? For a Hindu female, it will go to son, daughter and her husband. So children and husband. If children and husband are not there, then also it will not go to her parents. It will go to the relatives of her husband. This is something very ironical and difficult provision of Hindu succession law, that if husband or his children are not there, the property may not pass on to her parents, but it will still go to the relatives of her husband. We'll be discussing some interesting cases here. If no relative of her husband is alive, then the property will go to her parents. If her parents are not there, then the relatives of father. If the relatives of father are not there, then the relatives of mother. What a female can give, whatever she has in absolute capacity, she can give. If there is a life interest, she cannot give that. What is life interest? If a person says that, okay, after me, my house will remain with my wife, she will stay for her whole life in that house, and after her, it will go to so and so. So, एक केस हुआ था, एक सरदार जी थे, उन्होंने कहा कि मेरी जो कोठी है, जायदाद है, ये मेरी वाइफ जब तक जिंदा है तब तक इसमें रहेगी, उसके बाद ये मेरे भतीजों को चले जाएगी. अब भाभी जी ने सोचा कि यार क्यों किसी के लिए छोड़ के जाना, सब कुछ जो है गुरुद्वारे को दे दो. So she donated everything to the Gurudwara. After, the nephews of that person filed a case and Supreme Court held in the case of Sadhu Singh versus Gurudwara Sahib Narike that property भाभी जी को विल में देने का, डोनेट करने का अधिकार ही नहीं था. उनको केवल रहने का अधिकार था, वो लाइफ इंटरेस्ट था जो वो किसी और को नहीं दे सकती है. So it is important that what the female has in her own capacity, she is the owner, she can give. Something which she is not a owner, she has only interest in it, she cannot give. Then, see how complicated is Hindu law. If a female does not have children, she has her husband, but she dies before her children, what will happen? So, jahan se property आई थी, वहां चली जाएगी. If she had got some property from her father's house, it will go back to father. If it was received from her husband's family, it will go back to husband. But if she had children, nothing would pass on again to the father. Everything will go to the children and husband. But if children are not there, Hindu law says that the property will pass on to her father. जहां से प्रॉपर्टी आई थी वहीं वापस चली जाएगी. See, we'll again discuss some case studies. In this case, intestate female. This female is dying without making a will. She is leaving behind her husband, son, daughter, and mother and father. Who will get the property? So we all have discussed mother and father will not get anything. Husband, son, and daughter will get the property. Here, ex-husband and mother and father. So since the husband is no more husband, he is divorced, everything will go to mother and father. Third example, I am having my brother-in-law, देवर है और ननंद का बेटा भतीजा है. सो देखिए, देवर और ननंद अगर होते तो दोनों को मिलती, बट क्योंकि देवर है ननंद नहीं है, तो ननंद के बच्चों को नहीं मिलेगी, सब कुछ देवर को मिल जाएगी. देन ये हमने रमेश जेसिका का केस डिस्कस किया कि रमेश और जेसिका की इंटर रिलीजन मैरिज हुई. उसके बाद रमेश की डेथ के बाद में उसकी मदर है, जेसिका है, उसका बेटा है, बेटी है. किसको प्रॉपर्टी मिलेगी? तो रमेश भले ही हिंदू था, आखिरी दम तक हिंदू था, बट उसको हिंदू सक्सेशन लॉ नहीं लगेगा, इंडियन सक्सेशन एक्ट लगेगा. रमेश की मदर को कुछ भी नहीं मिलेगा, उसकी सिस्टर को नहीं मिलेगा, जेसिका को मिलेगा और रमेश के बच्चों को मिलेगा. ओनली दे विल गेट 1/3 जेसिका को, 2/3 रमेश के बच्चों. तो ये बहुत इंपॉर्टेंट है कि कब कौन से पर्सनल लॉज अप्लाई होते हैं, और जिसका कोई नहीं उसके लिए भारत सरकार होती है. अब 2-3 लाइव एग्जांपल्स आई विल शेयर. सुनीता जी वाज अ विडो हैविंग नो चिल्ड्रन. शी लिव्ड विथ हर सिस्टर्स चिल्ड्रन. वो अपनी बहन के बच्चों के साथ जिंदगी भर रही. उनके हस्बैंड की तो डेथ हो गई थी. जब सुनीता जी की डेथ हुई तो उनका एक बदमाश देवर, उनके हस्बैंड का भाई, जो शराब पीता था और बहुत ही जो है बदमाश था, वो आ गया कि मेरी जो है भाभी की प्रॉपर्टी मुझे दो. उनके भतीजों ने बोला कि आप 20 साल बाद आए हो, आप कैसे मांग सकते हो? बट सारी प्रॉपर्टी उसको मिल गई. क्यों? क्योंकि सुनीता जी ने विल नहीं बनाई थी, और विल नहीं बनाई थी तो सक्सेशन लॉस के हिसाब से अगर हस्बैंड और चिल्ड्रन नहीं है तो हस्बैंड के रिलेटिव को प्रॉपर्टी जाएगी. तो सुनीता जी देना किसी और को चाहती थी और मिल किसी और को गया. सो ये जो बहुत इंपॉर्टेंट है कि हम फ्यूचर में कोई हमको कोसे कल पे ऐसा नहीं होना चाहिए, जो है क्लैरिटी से देके जाना चाहिए. एक दूसरा और रियल लाइफ केस में आपसे डिस्कस करूंगा. महेश एंड सुनीता गॉट ए लव मैरिज. महेश अच्छा था, सुनीता के फादर को साथ में ले आया, अकेले थे तो अब महेश सुनीता ने एक नया फ्लैट लिया जिसमें सुनीता के फादर भी रह रहे थे. अनफॉर्चुनेटली महेश और सुनीता के एक्सीडेंट में डेथ हो गई. अब महेश का जो ब्रदर था, दूर का डिस्टेंट रिलेटिव था, वो आया और उसने सुनीता के फादर को बोल दिया कि मेरे भाई के घर से निकलो. उन्होंने बोला ये तो मेरी बेटी का भी घर था. बोले नथिंग डूइंग, और उनको निकाल दिया गया घर से. क्यों? क्योंकि सुनीता और महेश दोनों की प्रॉपर्टी महेश के रिलेटिव्स को जाएगी, सुनीता के फादर को कुछ भी नहीं जाएगा एज पर हिंदू लॉ. इसलिए विल बनाना जरूरी है. विल कब बनाए? तो आप एट द अर्लीस्ट स्टेज बना दें, बट विल बनाना बहुत जरूरी है. एक दूसरे एग्जाम्पल में अनीता और उसके हस्बैंड शादी के 7 दिन बाद अलग हो गए, पर उन्होंने फॉर्मल डाइवोर्स नहीं किया, और अनीता की डेथ के बाद जो है उसके हस्बैंड आ गए और सारी प्रॉपर्टी ले गए. क्यों? क्योंकि क्लैरिटी नहीं थी. ये मालूम था कि डिवोर्स हो गया है, बट क्लैरिटी से जो है उन्होंने उसको डॉक्यूमेंटाइज नहीं किया था. देखिए, हम लोग जब विल नहीं बनाते हैं तो प्रॉपर्टी कैसे क्लेम करेंगे? तो डिस्ट्रिक्ट कोर्ट जाके एडमिनिस्ट्रेटर अपॉइंट करेंगे और वो फिर प्रॉपर्टियों को बांटेंगे. सो इट इज ऑलवेज एडवाइजेबल टू हैव अ लेटर ऑफ एडमिनिस्ट्रेशन. इसको नहीं हो इसलिए विल बनाएं और विल में एग्जीक्यूटर अपॉइंट करें. तो सारे झगड़ों से बचने के लिए, जिसने सेवा की है उसको मेवा मिले, इन सब चीजों को इंश्योर अगर करना है तो विल बनाएं. पहले तो मालूम कैसे पड़ेगा कि वो आदमी क्या छोड़ के गया? व्हाट हैज ही लेफ्ट? सी, एम्प्लॉयर, if a person is working with the employer has details of the investments made by the employee. So from the HR department you can get the details. If there is a group insurance or employer insurance, you can get the benefit about that. Then if there is an investment made in post office, then Finacle software is used by post office. You can give PAN, Aadhaar number, or any other identification detail. Based on that, they'll give you a whole list of what all that person has left. इफ यू टॉक अबाउट फाइनेंशियल इन्वेस्टमेंट, म्यूचुअल फंड में कहाँ इन्वेस्ट कर रखा है कैसे मालूम पड़ेगा? तो कार्वी और कैम्प्स ये हैं. आप एज अ चार्टर्ड अकाउंटेंट यू कैन रिव्यू 3 year बैंक स्टेटमेंट एंड मेक अ ड्यू डिलिजेंस एंड अंडरस्टैंड व्हाट प्रॉपर्टी द पर्सन हैज क्रिएटेड. यू कैन रन थ्रू देयर कंपटीशन ऑफ इनकम. एंड वन थिंग व्हिच शुड every time be seen before making any will is caste. NSDL issues a consolidated account statement. This is a statement which comes to every month. Many times it happens that I may not know what investment I have made, but this is recorded here. This is a pen-based thing. Consolidated account statement is give you monthly details what you have. I have discussed the importance of nomination. मैं प्रॉपर्टी ए को देना चाहता हूँ, बी को नॉमिनी बना दिया, मेरे बाद दोनों झगड़ते रहेंगे. उसके बजाय पहले तो नॉमिनी किसमें है किसमें नहीं है ये कैसे मालूम पड़ेगा. तो ये जो एनएसडीएल का कंसोलिडेटेड अकाउंट स्टेटमेंट है, ये देता है आपके किस डीमैट अकाउंट, किस प्रॉपर्टी में, कौन से फाइनेंशियल इंस्ट्रूमेंट में कौन नॉमिनी है, कौन सा रजिस्टर्ड ईमेल है. आप देखें मेरा ये जो सेकंड वाला है, इसमें मैंने नॉमिनी रजिस्टर ही नहीं कर रखा है. क्लिक हियर, नॉमिनेशन नॉट रजिस्टर्ड. तो ये रेड फ्लैग रहता है. तो जब हम बिल बनाते हैं तो इस तरीके से ड्यू डिलिजेंस करके सामने वाले को बताएं, पूरा एक एक्सरसाइज हो कि भैया आपको ये, आप प्रॉपर्टी इसको देना चाहते हो तो नॉमिनेशन चेंज करो, इस प्रॉपर्टी में कोई नॉमिनी नहीं है तो उसको नॉमिनी बनाओ, तब हम प्रॉपर सक्सेशन प्लानिंग सर्विसेज दे पाएंगे. हाउ टू come to know about the immovable property. So now there are Sampada portal and different portals by different state government from which you can come to know about the property. In Madhya Pradesh, there is a Madhya Pradesh Bhu Abhilekh. From that website of Bhu Abhilekh, if you type the village name, if you have heard that, okay, my father has some agricultural land in this village, you go to district village, it will give list of everybody who is holding agricultural land in that village. So it is important. You should discuss with the friends of the deceased, because whatever you may not tell to the friends, basically family, it may be in the knowledge of friends. So it is very important. वो कहते हैं ना कि दिल खोल दो यारों से, नहीं तो खुलवाना पड़ेगा औजारों से. सो इसलिए दोस्तों से बातें करते रहें, दोस्तों के साथ में जो है इंटरेक्ट करते रहें, कई बार जो है बहुत अच्छा रहता है. Then moving ahead about testamentary will. What is a will and what are the different document we'll be studying? See, will is considered under Indian Succession Act 1925. It is a declaration. What Sumit Niwaji has given a very good word. It is a love letter for your future. You want to give to your relatives. So it is a legal declaration of testator's intention कि what will be done about the property. It can be created n number of times. Daily, आज मैंने will बनाई, कल मैं change कर दूं, परसों नहीं बना लूं. I can change it n number of times. There is nothing. Who can make a will? A person who can enter into a contract can make a will. He should be a major person of a sound mind. He should not be insane. But if he's a deaf, dumb, can he make a will? Yes, because he's of sound mind. He cannot speak or listen. That does not mean that he does not have a proper mind. कई लोग क्या करते हैं, will के अंदर witnessing, they get it done through a doctor. So if a doctor is signing, he's certifying that at the time of signing of this will, this person was having a proper state of mind. So there is a doctor certificate also at the time of signing of will. All these things are very important because when you do everything foolproof, you can charge good fees also for this succession planning services. Now, why to make a will? So I've already discussed to reduce disputes, to give property to whom you intend to give and not as per the different rules under the Indian and Hindu and personal religion succession acts. It can be revised whatever you want and you should make it as early as possible. Will should always be written. Oral will is allowed only for a soldier who is fighting a war and he's saying, okay, I'm going, मैं शहीद होने जा रहा हूँ, death charge पे जा रहा हूँ, and he tells his friend कि मेरी property मेरी wife को या बच्चों को दे देना. Only in that case and in case of some Muslims, oral will is allowed. Otherwise, will should be written. You should clearly mention whom you want to give the property. So designate benefit Shrees, legatees is important and it should be detailed. Many times it happens that you should give reason why you are giving how much to him. You may not give anything to your daughter and give everything to your son. So you can write that, okay, during my daughter's marriage, I have given everything to my daughter what she had. So therefore now I am not giving anything to her in the will and I am giving to my son. So whatever you want to do, there should be rationale which should come out of the will. Some essentials of the will. Date is very important because the last will prevails. It is the last will which will prevail. Identification, signature, witnessing, at least 2 witnesses should be there, and an executor. Who can be executor? Ideally, somebody who is of a younger age should be executor. And if the younger person is there and if he dies, what will happen? So you should have a primary and secondary executor. That I make Mr. A as my executor, but if Mr. A dies before me, Mr. B will be my executor. So you can make a primary and secondary executor. An executor should always be of a younger age. See these 2 lines. In one line, I have written, I leave all my money to my wife. And second line, I leave money to my wife. How much money, full money, half money, what money, which form, not written. So the second line is void. It should be clearly mentioned. I leave all my money to my wife. This is the important. So drafting wise, we have to be very careful. There should not be any ambiguous drafting. Who will be the executor? Executor is something very important. If you have not written executor in the will, then you will have to go to the court and get a administrator appointed. So you should always have a beneficiary who can be executor. Beneficiary should not be a beneficiary, should be executor. See, जो आदमी अपनी सबसे ज्यादा प्रॉपर्टी जिसको देके जा रहा है उसको एग्जीक्यूटर बनाओ, सो दैट पर्सन विल नॉट माइंड अगेन एंड अगेन गोइंग टू कोर्ट इन केस ऑफ एनी लिटिगेशन. Normally, it is seen that wife or somebody is made as an executor. In many cases, chartered accountants are made executor. But I would say, if a chartered accountant is being made as executor, you write about the fees in the will itself. There should not be any quarrel after the death of the person. So it is always advisable that a chartered accountant or a lawyer should become executor only if there is a clarity in the will about his remuneration also. Will executor can be primary, secondary. I have already explained. Then, who can be a witness? See, anybody who is of sound mind can be a witness, but somebody who is getting the property should not be a witness. मैंने बोला मेरे दोस्त को कि मिला यार दोस्त मैं तेरे को 1 करोड़ रुपए देके जा रहा हूं अपनी विल में, वो खुश हो गया, मिला तू मेरे विटनेस पे साइन कर दे. अगर वो विटनेस पे साइन कर देता है तो उसको जो 1 करोड़ रुपए मैंने विल में लिखा है ना वो नहीं मिलेगा. Beneficiary should not be a witness. Otherwise, whatever I am wanting to give to that beneficiary, it will become void. However, there is an exception that this will not apply to Hindus and Muslims. But as per Indian Succession Act, witness and beneficiary should not be same. You should avoid. आप किसी को प्रॉपर्टी दे रहे हो तो उसको विटनेस मत बनाइए. रिवोकेशन बाय मैरिज, दिस इज वेरी इंपॉर्टेंट. किसी व्यक्ति के जीवन की सबसे बड़ी घटना क्या है? जी मैंने घटना ही कहा, बिल्कुल ठीक सुना आपने. शादी. शादी ऐसी घटना है, एक तरीके से पुनर्जन्म है. So if a person has made a will before marriage and he gets married, so after marriage his will gets void. He will have to make a new will, fresh will after marriage. See, this is the importance of marriage. So marriage revokes a will. So it is important. However, again, there is an exception that this provision will not apply to Hindus and Muslims. But otherwise, we should ensure that a person who has made a will before marriage should definitely revise it immediately after his marriage, because marriage is a very important incident, and law has specifically provided under Section 69 that marriage revokes a will. So we should ensure compliance. Beneficiary, who can become the beneficiary? Anybody you can make a beneficiary. Your chartered accountant can also become your beneficiary. Your friend can also become stranger. Even animals can become beneficiary. Yes, you won't believe. A Mumbai-based couple, I was informed by Mr. Anup Shah, who is an expert. He discussed in his presentation that a Mumbai-based couple left 5 crores to their dogs. A designer Karl Lagerfeld in US, that designer left 2,700 crores wealth after him to his cat. So this is important that anybody can be your beneficiary. What the assets can be given? We know about the important assets, something important. Digital assets are also important. Email credentials, bank account. Even nowadays, your Facebook account and Instagram account, or if there is a password in WhatsApp, I have seen cases where people have written in the will that after me, my WhatsApp password should not be given to my wife, but it should be given to my friend only. So these are digital assets. So if the will is sent to Google, they will reset, or WhatsApp, they will give the password only to the person written in the will. So these are importance of digital assets and how the things are changing, world is getting dynamics. Then there is a concept of primary and secondary beneficiary. If a person writes, I will give everything to my wife, but before that person, if wife passes away, then who will get the property? I'll again have to make a will. In those cases, you should write that I leave all my property to my wife. However, in the event of my wife predeceasing me, the property shall give to my children, or whatever you want to write. So there should always be a primary and secondary beneficiary, so that you don't need to make or revise a will on the death of some relative or beneficiary. This is important, no contest clause. See what happens, somebody may challenge a will. So if will is getting challenged again and again, how would you protect challenging a will? So you can insert a no contest clause. This was found in the will of Ratan Tata, Michael Jackson. They have said that, okay, I want to give 1 crore rupees to this person. But if this person challenges my will, then he'll not get this 1 crore. So it acts as a deterrent to challenge the will to dispute. So if something is written, this no contest clause. Yes, it is very well accepted that this no contest clause has not been seen fairly by the courts. Courts do not entertain it, but this no contest clause is there, and it is a very interesting and useful tool to deter litigation, to reduce litigation in will cases. So this is a very interesting no contest clause which should be there. Now, after death of females, one thing is found that they fight, the relative fight. बहू बोलेगी मम्मी जी ने तो ये हार मुझे दिया था, बेटी बोलेगी नहीं नहीं मम्मी तो मेरे को दे के बोल के गई थी. So what should be done? And there are different jewelry names which we may not know. One har can be called Chandan har, Paua har, and whatever, whatever. So how do we know? So now what is being done? You click a photograph of that jewelry and attach it with the will and write, this is, I want to give it to so and so. So if this kind of attachment annexures are there in the will, it becomes very clear that what the deceased wanted to give to whom. So it preserves the relation, increases the bonding, and reduces disputes and brings clarity of the intention of the testator. Then again, ऐसा होता है ना वो that there was a movie Three Idiots. जब हम फेल हो जाए तो दुख नहीं होता, पर दोस्त पास हो जाए टॉप कर ले तो ज्यादा दुख होता है. Similarly, if I am getting something, it is okay. But if my brother or friend is getting more, then that will be painful for me. So there is a practice adopted by some solicitors that you don't tell how much you are giving to whom. You are writing, okay, I am giving assets mentioned in Annexure 1 to my son A, assets mentioned in Annexure B to my wife, assets in Annexure 3 to daughter. So now it is written, when you are giving the copy of will to son, you will give will with Annexure 1 only. To wife, Annexure 2 only. So that nobody knows how much has been given to whom. So this is also interesting annexuring practice while making wills. What can be given in will? Anything which is owned by you can be given in a will. A Mohammedan can give only 1/3 of his property, and tenancy rights cannot be given in case of a will. Right? Succession. See, if there are 4 partners, and after death of one partner, he writes in will, then after me, my son should be made as a partner. It will not become automatically unless there is a succession clause in the partnership deed itself. तो पार्टनरशिप डीड में लिखना पड़ेगा कि किसी भी पार्टनर की डेथ के बाद उसका लीगल हेयर पार्टनर बना दिया जाएगा. Then only it will be binding. Otherwise, automatically he will not become a partner. He will only get the share. Registration is not mandatory, but as said by Sumit Nimaji, it gives a timestamp, so it is very important to have registration. And even income tax gives recognition to a registered will. Undue influence. This is a very interesting case of Mahesh Kumar. Mahesh Kumar ने सुप्रीम कोर्ट में केस लगाया कि मेरे फादर बहुत बुजुर्ग थे और भैया के साथ रहते थे, भाभी रोज चाय पिलाती थी, उनको खुश रखती थी, भाभी जो है पिताजी का ध्यान रखती थी. तो पिताजी जो सब कुछ भैया के नाम लिख गए, वो इसलिए लिख गए क्योंकि वो अनड्यू इन्फ्लुएंस में थे. कोर्ट ने बोला फालतू बातें मत कर, जिसने सेवा की उसको मेवा मिला. आपने आपके पिताजी का ध्यान नहीं रखा, उन्होंने ध्यान रखा. तो क्योंकि वो ओल्ड एज से और क्योंकि वो आपके ब्रदर के साथ रहते थे, दिस डज नॉट मीन अनड्यू इन्फ्लुएंस. वो अगर सब कुछ छोड़ के गए हैं तो देयर इज अ रीजन फॉर दैट एंड यू कैन नॉट चैलेंज दैट रीजन. सो इट इज इंपॉर्टेंट. मियरली ओल्ड एज और लिविंग विद समबडी इज नॉट अ रीजन, बट यू शुड मेंशन. अगर आपने एक बच्चे को दिया, दूसरे को नहीं दिया, तो दूसरा चैलेंज कर देगा कि ये फॉर्ज है. तो जब अगर बिल में रीजन लिखा है कि उसको जो देना था मैं ऑलरेडी उसको दे चुका हूं, या उसके खर्चे उठा चुका हूं, या उसके हिस्से का उसको ऑलरेडी जो है मैं नहीं देना चाहता, इफ देयर इज अ रीजन मेंशन, दैट मेक्स योर विल अ बेटर साउंड प्रूफ विल. जॉइंट विल्स. हस्बैंड सेज मेरे बाद मेरी वाइफ क्या करेगी पता नहीं, वाइफ बोलती है हस्बैंड जो है मेरे बाद क्या करेंगे, तो दोनों एक साथ विल बनाते हैं. इंडिया में कॉमन नहीं है, बट फॉरेन कंट्रीज में इट इज कॉमन वेयर दे डोंट ट्रस्ट ईच अदर्स पार्टनर. तो जॉइंट विल इज अ कंसेप्ट वेयर after death of one, the other gets bound by the intention of that person. It should be avoided because it creates unnecessary complication. But where there is situation demands, then these kind of things are there. एक प्रॉपर्टी है, मैंने खरीदी, पूरा पैसा दिया और वाइफ का नाम जोड़ दिया, तो अब ओनर कौन है, मैं हूं या वाइफ? सो देयर इज अ डॉक्ट्रिन ऑफ इक्वल ओनरशिप. अगर दो लोगों का नाम लिखा है तो पैसा किसी ने भी दिया हो, इट विल बी अज्यूम दैट द प्रॉपर्टी इज ओन्ड बाय बोथ द पर्सन. कुछ कॉमन क्लॉजेस जो विल के अंदर होते हैं, दे आर देयर. अगर पूरी विल चेंज नहीं करनी, छोटा सा अमेंडमेंट करना है, तो उसको बोलते हैं कोडिसिल. कोडिसिल इज अडेंडम टू द विल. स्टाम्प ड्यूटी विल बनाने में नहीं लगती. देयर इज नो स्टाम्प ड्यूटी एप्लीकेबल फॉर मेकिंग अ विल. अ विल कैन बी मेड ऑन अ टिश्यू पेपर ऑल्सो. इन यूएस रिसेंटली 4,000 crores property was given on a will which was written on a tissue paper by a person when he was sitting idle in a hotel. Probate. See, this applies when the property is in the jurisdiction of Bombay High Court, Calcutta High Court or Madras High Court. 75,000 is the maximum fees for probate where the will is signed, sealed by the High Court. This is not a common concept and this takes time. So it is only applicable to Calcutta, Bombay and Madras High Court. For rest of India, this probate concept is not applicable. There are different succession documents like will, we know. Under will, there is a succession certificate which gives right to deal with debt and securities. If intestate debt is there, then court appoints an administrator. If legal heir certificate is given, it just creates management rights, no title. This is issued by Tehsildar. Some fake myths about will. It should be on stamp paper. No, not required. No legal format is there. Will can be changed n number of times. It is only applicable after the person's death. You cannot exclude your son, daughter. Sorry, you can exclude anybody and give it to anybody you want. Will need not be dated. Will must be dated because if there is no will, how will you come to know which is the last will? And it is the last will which prevails. Nomination prevails or will, rubbish. Will prevail in all the cases. Married woman cannot make a will. All women can make a will. There is no restriction. No need of witness. There is a need, at least 2 witnesses should be there and a physical witness. Recently, there was a case when a person did a video call, see, I'm signing a will, you will become my witness. That was not accepted in court because in India, physical witnessing is there. And marriage revokes a will. Yes, marriage revokes a will, but not in the case of Hindus. There is an interesting concept of ancestral property also. What is ancestral property? Pushtani Jaidad. After 1956 Hindu Succession Act, this concept of ancestral property has gone. अब पुश्तैनी जायदाद कुछ नहीं है. अगर मेरे दादाजी ने मेरे पिताजी को कुछ विल में दिया या बिना विल के भी मेरे पिताजी के पास आ गया, तो अब वो उनकी इंडिविजुअल प्रॉपर्टी है. वो जैसा चाहे उस प्रॉपर्टी का कर सकते हैं. उसके अंदर मेरा कोई अधिकार नहीं रहेगा. बाय अब जो एंसेस्ट्रल प्रॉपर्टी का कंसेप्ट है वो केवल एचयूएफ की अगर प्रॉपर्टी है तो उसी पे लगेगा. अदरवाइज ये कंसेप्ट नहीं लगेगा. गिफ्ट एक बार दे दिया तो दे दिया. बट कई बार ये इस तरीके के इश्यूज आए दैट पेरेंट्स after giving gift to their children had to suffer. Children did not take care. Then there was an enactment in 2007, Maintenance and Welfare of Parents and Senior Citizens Act. Section 23 says that even if there is no condition written in the will, it is implied that the children have to take care of their parents. And there are 2 decisions, Subhashini versus District Collector Madras High Court and Darshan Singh versus Rampal Singh, where it is held by the High Court that the property will go again back to the parents because children did not take care of their parents. So this is very important that even gifts can come back. However, we should avoid this kind of gifting. We should do everything with proper structuring only. Then nomination we have discussed. What is the hierarchy? Will is most important, then joint holder, then nominee. Taxation aspects. Yes, we will discuss some important taxation aspects also of wills. See, income tax, you have to get a representative SSC registered. And how will you get registered after that of the person? Your registered will or a nominee letter that you are nominee with that person in a bank or a joint holder. Based on this, legal heir registration is done by the bank. How will it be taxed? See, there are 2 things. एक व्यक्ति कि जिस दिन तक डेथ हुई उस दिन तक जो भी इनकम हुई थी, कोई भी 31 मार्च या 1 अप्रैल को तो मरेगा नहीं. 1 अप्रैल से फाइनेंशियल ईयर स्टार्ट हुआ, उसकी डेथ 30 सितंबर को हुई, तो 1 अप्रैल टू 30 सितंबर की इनकम उसी व्यक्ति के पैन नंबर के ऊपर उसके लीगल रिप्रेजेंटेटिव के हाथ में टैक्स होगी. लीगल रिप्रेजेंटेटिव बट पैन नंबर उसी का रहेगा. एंड आफ्टर दैट जो इनकम हुई है, अगर वो डिस्ट्रीब्यूट नहीं हुई तो एग्जीक्यूटर तब तक करेंगे और डिस्ट्रीब्यूशन के बाद जिसको इनकम मिल गई उसके हाथ में टैक्सेबल रहेगी. अब जब तक की इनकम होती है, ये बहुत इंपॉर्टेंट है, किसके हाथ में टैक्स होगी, कैसे टैक्स होगी. डिफरेंट लॉज हैं. सो इनकम टैक्स के अंदर भी इनकम अगर देखते हैं तो जिस दिन तक डेथ हुई उसी एसएससी के पैन नंबर के ऊपर लीगल हेयर्स उसके लॉगिन करके रजिस्ट्रेशन फाइल करेंगे. डेथ के बाद की जो इनकम है वो फिर उसके लिए सेपरेट पैन नंबर लेना पड़ेगा अगर इमीडिएट डिस्ट्रीब्यूशन नहीं हुआ तो उसका नाम रहता है एस्टेट ऑफ लेट मिस्टर सो एंड सो. इस तरीके से आप पेन लगाते हो, एस्टेट ऑफ एग्जीक्यूटर्स ऑफ एस्टेट ऑफ लेट मिस्टर सो एंड सो, इस नाम से आपको पैन कार्ड नया अप्लाई करना पड़ता है अगर डेथ के बाद भी प्रॉपर्टी डिस्ट्रीब्यूट नहीं हुई और बीच में कोई इनकम हो रही है तो. लीगल रिप्रेजेंटेटिव बाउंड रहेंगे टैक्स देने के लिए, बट ओनली टू दैट एक्सटेंट जितना उनको मिला है. अपने जेब से कुछ नहीं देना, जो भी प्रॉपर्टी मिला है उसके हिसाब से लीगल रिप्रेजेंटेटिव जो है, अच्छा जो टैक्स दे रहे हैं वो अपने पेरेंट्स के इसमें से ले सकते हैं. दे कैन जो भी प्रॉपर्टी उनको मिली है उस प्रॉपर्टी के अंदर से वो दे सकते हैं. देन कमिंग टू सम मोर इंपॉर्टेंट एस्पेक्ट्स, लीगल ट्रांसमिशन. जब एक पेरेंट अपने बेटे को इनहेरिटेंस में देता है या विल के थ्रू देता है, वो ट्रांसफर नहीं है, उस पर कैपिटल गेन नहीं लगता, ना देने वाले को कोई टैक्स लगता है ना लेने वाले को लगता है, क्योंकि 56(10) बोलते हैं अगर अंडर विल इनहेरिटेंस से कुछ भी मिला है सो दैट इज नॉट कंसिडर्ड एज इनकम, सो दैट इज अ ट्रांसमिशन नॉट ट्रांसफर। तो विल में जो दे रहा है और जो ले रहा है दोनों को नहीं लगेगा। अब कोई क्या होता है कि विल चैलेंज हो जाती है, तो एक व्यक्ति आया, दो बच्चे थे, एक बेटे को फादर ने सब कुछ दे दिया, दूसरा बेटा बोलता है भैया मैं विल को चैलेंज कर दूंगा, मुझे 5 लाख रुपए दो। अगर 5 लाख रुपए देता है वो विल को चैलेंज करने के लिए, तो टैक्स क्या लगेगा? ये 5 लाख रुपए कैपिटल रिसिप्ट है, इस पे कोई टैक्स नहीं लगेगा, बिकॉज इट इज सरेंडर ऑफ राइट टू कंटेस्ट अ विल, इट इज नॉट अ कैपिटल असेट, सो देयर वोंट बी एनी टैक्स ऑन दिस। कॉस्ट टू प्रीवियस ओनर, जो प्रॉपर्टी उसको विल में मिली है, जो प्रीवियस ओनर का होल्डिंग पीरियड और प्रीवियस ओनर को कॉस्ट मिली थी, वही पूरी कॉस्ट का बेनिफिट अब जिसको प्रॉपर्टी मिल रही है उसको मिल जाएगा। दिस वॉज अबाउट एस्टेट एंड सक्सेशन प्लानिंग other than private trust. Now, how can you do the private trust or other mechanism? See, एक और प्लानिंग होती है थ्रू शेयर्स। हस्बैंड वाइफ दोनों साथ में काम करते थे, दोनों की शादी हुई, कंपनी के 50-50% ओनर प्रमोटर हैं, बाद में बच्चा हुआ बट उनको अब आपस में डिस्प्यूट हो गया, दोनों सेपरेट हो रहे हैं, दोनों चाहते हैं कि कंट्रोल उनके पास में रहे बट प्रॉपर्टी बच्चे को मिले। तो इसके लिए सेक्शन 43 और 47 जो है उसमें प्राइवेट कंपनीज में एग्जेम्पशन है कि हाइब्रिड शेयर्स या डिफरेंशियल वोटिंग राइट्स के शेयर इश्यू हो सकते हैं। कैसे शेयर इश्यू होंगे? हस्बैंड वाइफ के पास जो शेयर्स हैं उनको एक्स्ट्रा वोटिंग राइट्स हैं, और बच्चे के पास में जो शेयर उन्होंने इश्यू करके दिए हैं उसको केवल डिविडेंड मिलेगा, वोटिंग राइट नहीं मिलेंगे। सो दिस इज वेरी इंटरेस्टिंग एंड इंपॉर्टेंट कि आप डिफरेंशियल वोटिंग राइट से भी सक्सेशन प्लानिंग इन लाइफ कर सकते हैं। प्राइवेट ट्रस्ट की बात करें तो दिस इज इंपॉर्टेंट, वेरी इंपॉर्टेंट। प्राइवेट ट्रस्ट क्या होता है? यहां पर जीते जी अगर आपको लगता है कि प्रॉपर्टी को कैसे मेंटेन करना, दिस इज नॉट अ टैक्स थिंग। टैक्स बेनिफिट्स प्राइवेट ट्रस्ट में नहीं है। प्राइवेट ट्रस्ट से आपको सॉल्यूशंस मिलते हैं कई सारे सक्सेशन प्रॉब्लम्स के। प्राइवेट ट्रस्ट क्या होता है? एक्सप्लेन यू इन ब्रीफ। सी, एक सेटलर जो प्रॉपर्टी ट्रस्ट में सेटल कर रहा है, ट्रस्टी जो उस प्रॉपर्टी को मैनेज करेगा, और सेटलर ने जो प्रॉपर्टी ट्रस्टीज को मैनेज करने के लिए दी, जिसके बेनिफिट के लिए दी है, वो होता है बेनिफिशियरी। तो सेटलर जो प्रॉपर्टी डाल रहा है, ट्रस्टी जो मैनेज कर रहा है, और बेनिफिशियरी जिसके लिए ये प्रॉपर्टीज हैं। ये ट्रस्ट का बेसिक स्ट्रक्चर होता है। कई बार ये होता है कि यार ट्रस्टीज उसको कैसे मैनेज कर रहे हैं कौन देखेगा? तो एक प्रोटेक्टर भी होता है जो देखेगा कि यार कैसे मैनेज हो रहा है। इसमें कॉन्ट्रीब्यूटर हो सकता है, जैसे मेरे दादाजी ने एक ट्रस्ट बनाया मेरे फादर के लिए। अब मेरे फादर ने सोचा मुझे पैसे की जरूरत नहीं है, तो उन्होंने भी उस ट्रस्ट में, अच्छे इन्वेस्टमेंट थे तो उन्होंने भी अपना पैसा उसमें डालना चालू कर दिया। तो सेटलर कोई और था, बेनिफिशियरी अगर खुद कंट्रीब्यूट कर रहा है तो वो डोनर कंट्रीब्यूटर बन सकता है। आप सेटलर, ट्रस्टी, बेनिफिशियरी इन तीनों में से 2 आउट ऑफ 3 बन सकते हो, तीनों नहीं हो सकते। आप सेटलर बेनिफिशियरी हो जाओ, ट्रस्टी कोई और हो जाएगा। आप सेटलर ट्रस्टी हो जाओ, जो फादर अगर ट्रस्ट बना रहे हैं तो उन्होंने ट्रस्ट बनाया, मैनेज भी वो करेंगे, और बेनिफिशियरी बच्चा हो जाएगा। तो ये 2 आउट ऑफ 3 हो सकते हैं, आप तीनों नहीं हो सकते, क्योंकि तीनों हो गए तो फिर ट्रस्ट की जरूरत ही नहीं है। तो यू कैन बी सेटलर बेनिफिशियरी, सेटलर ट्रस्टी, बेनिफिशियरी ट्रस्टी, दिस थिंग्स आर देयर। ट्रस्ट डीड अलग अलग चीजें होती हैं। ट्रस्ट का टैक्सेशन में बहुत शॉर्ट में कुछ इंटरेस्टिंग एस्पेक्ट्स आपसे डिस्कस करूंगा। स्पेसिफिक ट्रस्ट एक ट्रस्ट है जिसमें 4 बेनिफिशियरीज है, ए बी सी डी, चारों का अगर शेयर डिफाइंड है तो वो स्पेसिफिक ट्रस्ट हो गया। तो वहां पर टैक्सेशन होता है इन द लाइक मैनर एंड सेम एक्सटेंट। मतलब अगर ए बी सी डी, ए इंडिविजुअल है, ए बी सी इंडिविजुअल है, और डी जो है चैरिटेबल ट्रस्ट है, तो इंडिविजुअल्स को ए की इनकम है मेरी 1 करोड़ रुपए साल की, बी की इनकम है 1 लाख रुपए, और सी की इनकम जो है हो सकता है मेरी 10 लाख रुपए हो। अब कैसे टैक्सेशन होगा? इन द लाइक मैनर एंड सेम एक्सटेंट स्पेसिफिक ट्रस्ट में। इसका मतलब क्या होता है? तो जो ट्रस्ट को अगर 3 लाख का प्रॉफिट हुआ तो वो जो ए को मिलेगा, तो ए का स्लैब था 42% का, तो ए के हाथ में 1 लाख रुपए पे टैक्स आएगा 42,000। बी के हाथ में 10 लाख का था तो उसको टैक्स लगेगा 20%, तो 20% जो होगा 1 लाख पे 20,000। तो ए का टैक्स हुआ 42,000, बी का हुआ 20,000, और सी की तो इनकम जो है टैक्सेबल नहीं है, तो सी के हाथ में एग्जेम्प्ट रहेगा। तो तीनों का टैक्स टोटल करेंगे, और वो जो 42 प्लस 62,000 रुपीज टैक्स लगा आपकी 1 लाख रुपए, 3 लाख रुपए की इनकम पे। तो इन द लाइक मैनर एंड सेम एक्सटेंट जो बेनिफिशियरी को लगेगा वो रेट। अब इसमें बेटर ये है कि आप अगर बेनिफिशियरी के हाथ में वो इनकम ऑफर कर देते हैं तो ट्रस्ट के हाथ में डबल टैक्सेशन यहाँ पर नहीं होगा। एक और इंपॉर्टेंट चीज, सेक्शन 56(2)(10) में जो अमेंडमेंट आ गया है, अब अगर आप ट्रस्ट में कोई प्रॉपर्टी डाल रहे हो तो वो ट्रस्ट के हाथ में टैक्सेबल हो जाएगी अनलेस वो प्रॉपर्टी, जिसने प्रॉपर्टी डाली है सेटलर ने, वो अपने रिलेटिव्स के लिए डाली है। तो अगर मैं एक ट्रस्ट बनाता हूं अपने बेटे के लिए, जिसका बेनिफिशियरी मेरा बेटा है, केवल ओनली सोनली फॉर द बेनिफिशियरी ऑफ योर रिलेटिव, तो उस पर टैक्स नहीं लगेगा। पर मैं बोल दूं कि मेरे दोस्त के लिए मैं एक प्रॉपर्टी जो है सेटल कर रहा हूं, कि उस या 1 लाख रुपए ट्रस्ट में डाल रहा हूं जिसमें मेरा दोस्त बेनिफिशियरी है, तो वो ट्रस्ट के हाथ में 1 लाख रुपए पे टैक्स लग जाएगा 56(2)(10) के अंदर। ट्रस्ट का स्टेटस क्या होता है? तो देखिए, ट्रस्ट का पैन कार्ड तो एओपी से आता है, पर उसका जो स्टेटस रहेगा दैट इज बेस्ड ऑन द स्टेटस ऑफ इट्स बेनिफिशियरी। अगर सारे बेनिफिशियरीज इंडिविजुअल हैं तो ट्रस्ट का स्टेटस भी इंडिविजुअल हो जाएगा। दो ट्रस्ट होते हैं, स्पेसिफिकरी और डिस्क्रिशनरी। डिस्क्रिशनरी मतलब जिसमें राम भरोसे है, मुझे नहीं मालूम कि किसको कितना जो है, ये ट्रस्टी के ऊपर है, बेनिफिशियरी मांग नहीं सकता। जैसे मेरे 2 बच्चे हैं और मैंने अपने फ्रेंड को बेनिफिशियरी ट्रस्टी बना दिया, और ये डिस्क्रिशनरी ट्रस्ट है। तो डिस्क्रिशनरी ट्रस्ट में क्या होगा, वो ट्रस्टी जब देगा तभी उनको मिलेगा। ये लोग ट्रस्टी से मांग नहीं सकते, ट्रस्टी के ऊपर है। तो जहां पर बेनिफिशियरी के हाथ में एक रे ऑफ होप है कि हाँ मुझे कुछ मिल सकता है, पता नहीं मिलेगा नहीं मिलेगा, तो वो होता है डिस्क्रिशनरी ट्रस्ट। डिस्क्रिशनरी ट्रस्ट में टैक्स लगता है ट्रस्टीज के ऊपर। ट्रस्टीज का सेपरेट असेसमेंट होता है, और इसमें नॉर्मली एमएमआर लगता है, मैक्सिमम मार्जिनल रेट। अब ये डिस्क्रिशनरी कब बनाते हैं? देखिए, असेट प्रोटेक्शन, एक फैमिली के पास में घर है, पैसा है, और अब वो एक्सपांशन बड़ा लोन ले रहे हैं, पर्सनल गारंटीज लगती हैं। पर्सनल गारंटी अगर बाद में लोन डिफॉल्ट हो गया तो वो बर्बाद हो जाएंगे, उनका सारा घर वार बिक जाएगा। तो ये करने के पहले कई बड़े बिजनेस हाउसेस क्या करते हैं कि जो मेरा एक घर है मैं उसको ट्रस्ट में डाल देता हूँ, डिस्क्रिशनरी ट्रस्ट में। डिस्क्रिशनरी ट्रस्ट में डाल दिया, तो जब वो प्रॉपर्टी इंसॉल्वेंट भी हुआ या एसएससी इंसॉल्वेंट हुआ, तो वो जब प्रॉपर्टी क्लेम करने जाएगा बैंक, तो बोलेंगे ये तो ट्रस्ट की प्रॉपर्टी है और बेनिफिशियरीज के पास भोग के अलावा कुछ नहीं है, और ट्रस्टीज अलग हैं। तो इसलिए वो असेट प्रोटेक्शन ट्रस्ट बोलते हैं। या एक कपल की शादी हुई, हस्बैंड वाइफ की, बट उसको लगता है कि मेरी वाइफ बाद में मेरे को डाइवोर्स देके आधी प्रॉपर्टी ले जाएगी, तो वो हस्बैंड की प्रॉपर्टी ट्रस्ट में डाल दी, जिसमें हस्बैंड बेनिफिशियरी है, बट वो डिस्क्रिशनरी ट्रस्ट है जिसमें उसके फादर जो है ट्रस्टी हैं। तो वो क्योंकि उसके पास में रे ऑफ होप से ज्यादा नहीं है, तो ऐसे केस में वाइफ पूरी प्रॉपर्टी नहीं ले जा सकती। इसलिए भी बहुत सारे जो मैरिजेस होते हैं उसके पहले स्पेसिफिक ये जो डिस्क्रिशनरी ट्रस्ट है इसका यूज होता है। तो 2 इंपॉर्टेंट ट्रस्ट है, स्पेसिफिक ट्रस्ट, डिस्क्रिशनरी ट्रस्ट। तीसरा ट्रस्ट जो होता है वो होता है टेस्टामेंटरी ट्रस्ट, कि कोई व्यक्ति अपने बाद अपने विल में छोड़ जाए। देखिए, अगर आपकी बिजनेस इनकम है तो आपका चाहे स्पेसिफिक हो, डिस्क्रिशनरी, कोई भी ट्रस्ट हो, उसमें एमएमआर पे लगेगा। ओनली एक्सेप्शन इज अ टेस्टामेंटरी ट्रस्ट, कि अगर टेस्टामेंटरी ट्रस्ट है तो आपका जो भी स्लैब रेट है उसके हिसाब से लगेगा, आपको एमएमआर नहीं लगेगा। अदरवाइज स्पेसिफिक ट्रस्ट जो बेनिफिशियरी का टैक्स रेट है वही उनका टैक्स रेट हो जाएगा। हम अगर
Excuse
बात
me,
करें,
sir. Sorry to interrupt. So, can you
Yeah.
please speak in English? Participants are a bit.
okay, no issues, sir. I'll speak in English
Sorry for
also.
interruption.
Or no, no, we can have 2 seminars also, one for Hindi audience and English audience also. So specific trust, discretionary trust, and the third type of trust is the testamentary trust, which is important. These 3 type of trust are there. Specific trust, taxation is like manner, same extent. Discretionary trust, everything is taxed in the hands of trust at the maximum marginal rate. The only exception is the decision of Kamalini Khatau Supreme Court, where it is said that if the property is distributed or any amount is distributed by the trust to the trust beneficiaries during the year, that will be taxed in the hands of beneficiaries at their rate. It will not be subjected to MMR in the hands of trust for discretionary trust. But otherwise, specific trust, like manner, same extent as beneficiaries. Discretionary trust, everything in the hands of trust at the MMR. And testamentary trust, the rate applicable to the normal slab rate. Only condition is the only trust which is created for those beneficiaries. These are some important things. Then there is some tax planning also done under a specific and discretionary trust. For example, if for a trust is made for a minor, so that minor a specific trust is made, in those cases that minor specific trust will be a separately assessed file, and you will get the benefit of basically slab rates. So these kinds of different trust and structuring planning is there, which can be discussed. We can discuss queries also, because important thing, how to migrate assets to the structure of the trust is also very important, because when you are migrating, you have to see FEMA, tax, stamp duty, all the impacts which Sumit Nimaji said in the beginning, because stamp duty rates are high in various cases. There are different laws which you need to see. There are professional trustees also, which are there, who manage the properties of a trust. So bank, financial institution, they charge a fees. Normally for creation of trust, 5 lakh rupees is the basic amount which is being charged. It is done for some HNIs. What is the use of trust? I have already given you example of divorce cases, asset protection. In case of disabled child, father and mother are earning, but they know that their child is disabled, and after them, who will take care? So they'll create a trust, make a friend as a trustee, and the benefits return will go automatically to that child. So this is child protection trust. These kind of trusts are also being made. There are different kind of structures in the trust kind of things which have to be dealt in detail. There is a very interesting concept, rule of perpetuity. What is rule of perpetuity? And what about stamp duty? Yes, this is a very interesting thing. Normally, you don't enter everything, give whole wealth in the trust deed. Initially, the trust deed is created with basic amount like 10,000. So that stamp duty is limited up to the creation. After that, whatever you contribute is a movable property, no stamp duty is there. So all the trusts are created initially with a amount corpus of 10,000, so that the stamp duty impact is minimized. A trust, if immovable property is there, it has to get registered. Then rule of perpetuity. Normally, what is the life of a trust? So life of trust depends upon the last beneficiary or the youngest beneficiary. Till the life of that beneficiary, this trust will be there. So this rule of perpetuity is a very interesting, important aspect, which is there since there. Maximum duration is rule of perpetuity. There are interesting aspects. I'll share my presentation, which will be there in that. And minor children tax planning. See, because our focus today is not on private trust, but through estate and succession planning through those trusts. So your minor children's family trusts are made for education of that child or marriage of your child. Trusts are created by those families, which is assessed as a separate legal entity. There is a decision of Supreme Court in the M.R. Doshi, which says no clubbing of the income of that trust in the hands of that parents or the trustees. So a minor children tax planning is done basically through trust, and it is a valid, legitimate tax planning approved by Supreme Court. So this was all about private trust. It's different kind of structure, estate planning. So one thing is very important. We should dwell in this kind of practice. We should know the succession laws. We should advise our clients on the basis of succession laws and ensure that each and every of our clients should have a will made. And before making will of your client, you should first make your own will. It is very important. Our will should be there. Then only we can preach our clients to make a will. So will is something which is a future love letter to your family, to your future beneficiaries, legatives. So with this, I would conclude my presentation and keep it open for any queries if there are. Thank you very much for such a patient hearing. My number is there. If any queries are there, you can anytime connect with me. And thank you very much for being there. Thank you, Sumit sir, because now I would like to listen your concluding remarks also, because as a legal luminary, you have seen many cases. Whatever I have discussed, you can vet these things. See, a chartered accountant normally does a planning or structuring, and a counsel vets that planning, whether how much it is prone to litigation and things. So thank you very much for such a patient hearing. Thank you to the committee. Over to MOC.
Thank you, sir, for amazing webinar. And there are just two questions which I want to ask on behalf of the participants.
Yes.
First one is whether my uncle, second wife's son, or daughter can have a right in grandfather's property. Uncle expired in 1993, grandfather in the same year.
The uncle's
This is-
second wife's children. So you mean to say that second wife was invalid or something like that, and children? So children will always have right in their father's property. But if your grandfather has left it interstate or through a will, that is important. If it is through a will given to father or your uncle, then his children will have a share. But if it was not through a will, it was interstate, then equal proportion as per class 1 legal heir will dwell upon it. So definitely your uncle's children will have a right in their grandfather's property, no doubt about that. Second query which I can see, can a wife and son be made executives of a will? yes, they can definitely be and they should be executors because they are the one who are actually going to follow up for that property. So they should be made executives of the will.
Okay, sir.
And it is
Thanks
advisable
for
that you make one executor. If you make both them executor, then the status will be AOP for technical purposes in the income tax assessments of the estate of that deceased person.
okay, sir.
Sumit sir, some words of wisdom.
No, nothing. I just wanted to emphasize that
Yes.
there should be a will for these accounts, your Google accounts, your Facebook accounts, your social media
Digital
accounts,
assets.
and
Yes.
also who would control them after your death, whether they are to be shut down or whether they will continue with your legacy. And because nowadays Google and Facebook both demand this will for continuation, otherwise they shut it down.
Okay.
So that legacy, if you want to maintain, then of course that will should include that provision. And another thing, Pankaj, now living wills are also recognized in India because if you want to ensure that you don't suffer a lot at the time you are there with the tubes attached to your mouth, when you are almost brain dead, and you want to ensure that you don't become a burden on your family and you want to pass away peacefully. So a living will helps in executing that, where the doctors certify that there are no chances of survival. Then a living will gives your say in that matter, that you want to end your life that way peacefully. So these are the two aspects in the modern world: a living will and your social media accounts, your cryptos, etc., etc.
Great, sir. Thank you so much.
That was a great suggestion, sir. So, shall we conclude?
Yes, I think.
Yeah, it's
Thank you,
almost
Man.
So I
47.
thank
Yeah.
I thank Pankaj sir and Sumit sir for their expert advice on the will formation. It was a very new topic for me also, and it has a very vital scope in future, like will formation, and we can guide our clients on the same matter. And I thank Committee on Corporate Law, Economic Advisory, and NPO Cooperative of ICI for organizing such an informative session with so prominent speakers. We thank you, sir.
Yeah. Okay. Thank you. Thank you. Take care.
Thank you, sir.
Bye, Pankaj.
Thank you, sir. Thank
You
you.
are in Indore or again?
Indore,
outside?
Indore, today Indore.
Okay, good. Chal,
Right.
take care.
Correct.
Bye bye.